a very good morning, afternoon, evening, depending on which geographical location you are at the moment. Thank you so much for joining, and thank you so much, Aurelio, for having taken the time out to talk to us today about your paper. I'll just very briefly introduce Insolvency Law Academy for the benefit of those who may not be familiar with our work, our existence for that matter. And I'm actually quite excited and even proud that today we are having this conversation on the third anniversary of the setting up of Insolvency Law Academy. We are just about 3 years old. And 3 years is a very short time in the life of any institution, as you know. And we are not even infant for that matter. We are not even a toddler for that matter. But we've taken long strides, very firm, long, formidable strides in the last 3 years, created impressionable footprints, not just within the country, but beyond, have built a very, very, if I may say, partnerships that are very effective globally within the country. We have created in the last 3 years some very influential literature, which has already impacted the insolvency policy. Essentially, we are a think tank, a thought leader, a research institution, helping the government develop policy and create a robust insolvency system in the country. In a way, central to our goal is to help the government of India, regulators, the market, in the advancement of India's goal and aspiration to become a developed country by 2047. And as a part of that, our Insolvency Law Academy is trying to bring thought leadership in this area, in the country, in the region, with the aim of building an architecture which will meet the standards expected of a developed economy and a matured economy, if I may say. And as a part of these various initiatives, we have set up many platforms, many forums, and one of them, which is one of the key voices and something which is very dear to my heart in person as a founder of this academy, is the task force for emerging markets development economies, insolvency systems. And the reason why we thought that we should have this task force is because we believe, as in our journey as India, since 1991, when we liberalized our economy, that we have been very dependent on importing or learning from the various systems, best practices, standards, legislations, regulations that have been developed by sophisticated economies in the global north from the time the modernization of the insolvency law system happened. And most of the countries, including India, for that matter, in global south, have been mostly spectators, consumers of those best practices, often when invited as sitting as a backbencher in most platforms, global head tables. And while we have benefited immensely from the learnings, experiences of developed systems, we do also feel that we have not done enough in our parts of the world to be able to appreciate the compatibility of what we have borrowed or what we have been told to implement with the local dynamics. And often the experiments with these systems haven't really worked as well. While at the same point in time, like in the case of India, in our insolvency law, which was enacted in 2016, where we did borrow certain good practices and we benefited from it as well. But our experience with those choices that we made, which were indigenous, which were completely localized, has been that they have been more successful than the ones that have borrowed. And we just thought that therefore there is a merit in therefore creating a platform, and which is what this task force is, which in a way echoes the voice of the global South economies in terms of what they consider is, in their views, the most suited insolvency law and other systems that operate in its overall ecosystem architecture, that they need to be localized, customized. And at the same point, I'm also share our experiences, which may also benefit not just our peers in the global South, but also perhaps in global North, where also the experiences have shown that some of the things have not really worked as well, and we've had to change too often. And when we set up this task force, we were so delighted that Aurelio, when I spoke to him, was willing to take the responsibility of heading the task force, because he has done extensive work on this and something that resonates with India. I remember that the Indian regulator invited him as a keynote speaker at one of their international conferences about 4 years ago, which meant that he already has created an impression in our parts of the world. And I think his voice is impressionable, reasonable, and often challenging, provoking as well. But that is what we need when we need to be heard, and heard well, with patience as well. So thank you so much, Aurelio, for having agreed to chair this task force, of course, which comprises of many other very eminent scholars from around the world. Today, the purpose of this event seminar is for Aurelio to share his most recent paper focused on the insolvency systems in the countries in the global South. And of course, at the same point of time, sharing with us his experience also of having studied deeply the systems in global North, and therefore to be able to distill out of them what he believes is good for the economies in global South, and something out of that which may also be good for the global North countries. And of course, this comes very close to the heels of his book, also with the system which Aurelio have also liberally borrowed from in my book, which is coming out next month, which, thank you, you agreed to write the blurb for. And I think I'll leave it here and then hand over to you, Aurelio. And what we'll do is we'll hear you for about 25 to 30 minutes, and then open it up for discussion for another 10 to 15 minutes, depending on how the flow is. And over to you, Aurelio.
Yeah, thank you so much, Suman, for this kind introduction. My sincere gratitude also to Insolvency Law Academy for providing this type of platforms to share research, and also for the amazing work that Insolvency Law Academy has done in the past 3 years, including the creation of this important task force on emerging markets and developing economies. So thank you, everyone, for joining us today. I can see some familiar faces here, and hopefully on YouTube, we will have also people from both the Global North and the Global South listening, because I am very interested in your views about this paper that I've recently written about insolvency law in the Global South, and what the Global North can actually learn from the Global South. So as Sumant was mentioning in his opening remarks, the Global South typically is a consumer of many laws and practices existing in the Global North. So if we think about, for example, many insolvency laws in Africa, particularly Nigeria, Ghana, Kenya, we can see that actually they replicate practices and laws and proceedings mainly existing in the United Kingdom. If we look at Malaysia, right now, Malaysia has recently amended its insolvency law and has virtually replicated the insolvency and restructuring framework existing in Singapore. If we look at China or Thailand, they have adopted provisions from Chapter 11. If we look at Brazil, has recently in 2020 adopted certain features from Chapter 11, but also Brazil has certain features from European proceedings, mainly France. Uruguay in Latin America has an insolvency process that also shares many similarities with the insolvency process existing in Spain, and particularly an insolvency bill, a proceeding that was envisioned in an insolvency bill that was debated in Spain in the 90s. And actually, when we think about legal transplants, when we think about global trends, and when we think about insolvency reforms around the world, we typically hear about the influence of Chapter 11, right? The Chapter 11 is everywhere. Latin America, Europe, Asia, Africa. We think about the UK-style administration proceeding, that again is the proceeding that has been adopted in some African countries, for example, and many other common law countries, particularly in Asia. We think about the rise of pre-insolvency proceedings, the type of preventive restructuring frameworks that were popularized in Europe are now becoming more relevant internationally. Many Latin American countries, in some African countries, in some countries in the Middle East, now we can see this type of pre-insolvency proceedings, mainly from Europe. So it seems that the common denominator of all of this reform is that the global north, or some proceedings and practices from the global north, are influencing reforms in the global south. If we look at what's going on around the world, we can actually see a greater level of convergence in the design of insolvency laws. More and more countries now are adopting a cross-class crackdown. More and more countries are adopting deep financing provisions. More and more countries are adopting pre-insolvency proceedings or hybrid proceedings such as pre-PACs. If we look at the European Union, now has an insolvency process, a restructuring process that includes many features from Chapter 11. The UK restructuring plan features from Chapter 11. Singapore features from Chapter 11. It seems that Chapter 11 is influencing reforms everywhere. And then also not only Chapter 11. So for example, until a couple of years ago, the World Bank used to publish the Doing Business report, and the Doing Business was influencing many insolvency reforms. In fact, many regulators around the world were saying, well, we amend our insolvency laws because we want to improve our position in the Doing Business report. They thought that that was a good idea, maybe to attract investments and to attract, foreign investors to their countries. And actually, the Doing Business included certain features of an ideal, optimal insolvency system. And those features, interestingly, were features mainly from the US Chapter 11. So that's why, again, the Global North influence, in this case, an international index that is supposed to represent international best practices. And this international index with international best practices was influencing insolvency reforms around the world. Sometimes this process of convergence is due to other factors, like regulatory competition, for example. So Singapore wanted to compete in the international space to attract foreign companies to restructure in Singapore. So that's why Singapore looked at the US, which is one of the main restructuring centers around the world. Many companies from Latin America, from around the world, go to the US to restructure there. And Singapore said, well, maybe there is something that we can learn from the US. So that's why Singapore ended up adopting certain features from Chapter 11. The UK said, well, we cannot be behind, because on the one hand, Singapore now has amended the law, becoming even more competitive internationally. And secondly, the European Union now has adopted the new directive on preventive restructuring frameworks, meaning that European insolvency law is going to improve. And that's why many Spanish, French, German companies that used to restructure in the UK, maybe they want to stay in Europe because Europe was planning to modernize it had actually done its insolvency and restructuring framework. So that's why the UK said, well, we cannot be behind. Let's improve our framework. And the way to do so is, among other things, by looking at Chapter 11. Also in the EU, we can see a greater level of convergence, in part because it is imposed by the European Union as a way to develop the capital market union. Among other reasons, the European Union decided that Europe should have a minimum level of harmonization when it comes to insolvency and restructuring laws. So in the first directive, we have found this harmonization in the context of pre-insolvency proceedings or preventive restructuring frameworks. And now the European Union is also discussing a greater level of harmonization in the context of formal insolvency proceedings as well. But we find this process of global convergence. The interesting thing about this global convergence is that typically practices and ideas move from the global north to the global south and not the other way around. And why is that? Why Chapter 11 is influencing reforms around the world? Why the European style pre-insolvency proceedings are influencing insolvency reforms around the world? Why the UK administration proceeding has been adopted in some countries in the global south is because of the superiority of these proceedings, is because of colonialism, or because of legal origins, because the UK adopted this. So Nigeria or India or Kenya, because of the legal origins and because the UK did this, now we should adopt this. It's because of that. It's because maybe the academic and policy debate on insolvency is more active in the global north. And that's why maybe the global south doesn't have a strong voice in these debates, precisely because of that. That can be one of the many reasons. I would like to congratulate again Sumant, Batra, and Insolvency Law Academy for facilitating this type of platforms and promoting this type of debates, putting the global south on the map, because sometimes we feel that there is a stronger academic and policy debates in the global south, and maybe because of that, even if the global south is represented in many international organizations, ultimately the global south may end up adopting some practices that have been more heavily discussed in the global north. It's because maybe the global south wants to replicate the economic success of the global north. And maybe we say, well, if the US has done very well economically, if I am Mexico or if I am Thailand, I can replicate insolvency laws from the US as a way to replicate the economic success of the United States. Well, unfortunately, this argument seems to ignore the fact that correlation and causation. First of all, it doesn't distinguish between correlation and causation, and even the direction of the causation, because maybe the US has done incredibly well, even with an inefficient insolvency process, but still there are many other economic factors in their economy that has led to this economic success. And the same in other countries in the global north. Maybe they have done incredibly well economically, despite the fact that they have inefficient and sometimes value-destroying insolvency proceedings. So that's why, again, this argument is not very convincing either. Sometimes people say, well, in countries like Ecuador, reorganization proceedings are not initiated very often. On average, Ecuador is having about 1.5 reorganization proceedings per year. And some people say, well, that doesn't seem to be a successful restructuring proceeding. Other countries have thousands of reorganization proceedings a year, so why not adopting these proceedings or practices existing in those proceedings, typically from the global north, to have a more successful, well-functioning insolvency process? Again, this argument also ignores a very important point in comparative law, which is that context matters. And maybe something works very well in the US, but that doesn't mean that it's going to work very well in countries with totally different legal and institutional environments. So that's why I was fascinated by this fact, the fact that the global north has directly or indirectly through international indexes, etc., influence insolvency laws and practices in the global south. So as Sumant mentioned, in the past few years, I've been working on two main projects. One is a book on insolvency law in emerging economies. And the second one is a global insolvency index. As part of that project, that index, I've been analyzing insolvency laws in about 75 jurisdictions around the world, So that's why I had the chance to explore very much in detail, in depth, the features of insolvency laws and practices and proceedings in many countries around the world. So that's why, inspired by a fascinating paper and also a recent book published by Professor Mariana Pargendler, professor of law at Harvard Law School, she said basically that the Global South has innovated in many aspects of private law. And particularly, she wrote a fascinating article a couple of years ago saying that the Global South has innovated in some aspects of corporate law and corporate governance. One of the examples that she mentions is that many countries like Brazil, like India, like China, have stakeholder-oriented provisions in their corporate laws. So in other words, the directors need to act in the interest of the corporation, meaning usually the shareholders as a whole, but also in the interest of a variety of stakeholders. That's the case in India, in Brazil, in China, many other countries around the world. So interestingly, many academics from the global north in the past few years have been saying that the global north, the US and the UK and other countries, should embrace this stakeholderism. And that's why Professor Pargendler said, well, these stakeholder-oriented provisions in corporate law is not new. This is not something invented now by academics in the global north. This is something that has existed in the global south already for many years. That's why in another fascinating article, my colleague from SMU, Dan Puchniak, said that there is no need for Asia to be woke. That was the title of the paper. And what he meant by not need for Asia to be woke is that Asia doesn't need to embrace all of these stakeholder-oriented provisions because many Asian countries, including Japan, India, China, already have some stakeholder-oriented provisions. So that's why the main point that Professor Pargendler emphasized in this fascinating article and then in her book is that the Global South has innovated. That was one of the main takeaways from her article. And she said also something very important, which is that we need to include the Global South in the study of comparative corporate law and governance. Because if we include the Global South, she mentioned something incredibly important that I emphasize here in the slides, we can enlarge our institutional imagination. But at the same time, we can enrich our own understanding of corporate law around the world. So that's why, motivated by my previous work on insolvency law in emerging economies and by what I've learned from this Global Insolvency Index, and then after reading Professor Pargendler's fascinating work, I thought, well, maybe in the context of insolvency law, there are some interesting innovations. And I'm saying interesting. I'm not saying necessarily good or bad innovations, but at least innovation. That was my starting point, to look at the Global South more closely to see whether we can find innovative aspects in their insolvency laws. And maybe, who knows, maybe some of those innovative aspects can be useful for the Global North and for other jurisdictions in the Global South or not. But I wanted to at least test Professor Pargendler's hypothesis in the context of insolvency law to see if there is any interesting features in insolvency laws in the Global South. And spoiler, the conclusion is yes, I found an interesting aspect that I'm going to discuss later. But before that, let me say a couple of more words about the motivation of this study and why I think it's important to do what Suman Batra mentioned, which is to put the Global South on the map, and is what many of us are trying to do through our scholarship. So if we look at the comparative literature on insolvency law, the Global South is never there, or at least not very often. And I find that very interesting, that sometimes a paper on comparative insolvency law compares the US, the UK, and Germany. Or maybe, if we're very lucky, they also include France. Or maybe we're very lucky, the author includes his or her jurisdiction. Imagine that you are from Colombia. I can see some people from Colombia joining us here today, some good friends. I can see some people from Canada, or imagine that we are from Australia. So of course we include our jurisdiction, Australia, Colombia, Canada, and then we compare Colombia and Canada with the US and the UK. That's generally the approach in many comparative studies on insolvency. In the past few years, we can see more studies, including places like India or places like China, or for example, people from Brazil may compare Brazil with, some jurisdictions in the global north, mainly Europe and the US. But I miss something in the literature. I would like, actually, part of my motivation is because I wanted to know more about countries like Uruguay. I wanted to know more about countries like Pakistan. I wanted to know more about the Philippines. And I wanted to know more about jurisdictions that are not typically covered in many of these studies. So that's why I think it's important to include these jurisdictions because, first of all, we can learn a lot from those jurisdictions. And as Professor Pargendler mentioned, I think they can, including these jurisdictions, can enlarge our institutional imagination. And who knows, we might end up coming up with solutions for our own jurisdictions as well. So, and also when I started to think about why we, and but say we, because I, in my research also in the past, been doing a lot of research comparing Europe, comparing the US. So why many of us and why the literature has been so obsessed with the global north, and particularly with Chapter 11. Chapter 11 is now in every single conversation. If you are in a conference in Asia, they speak about Chapter 11, of course. If you are in Latin America, they speak about Chapter 11. And if you are in Europe, of course, they speak about Chapter 11. And the truth is that Chapter 11 has been very influential worldwide and very popular. It seems to be like the paradise of insolvency law. So we all admire Chapter 11. We all want to be like the US when it comes to insolvency law. But they found something very interesting. Those people that typically admire Chapter 11 are generally foreigners. If you talk to some people from the US, or if you read the literature, particularly the economic literature or the law and economics literature, Chapter 11 is always criticized. Chapter 11 is very expensive, very costly, very lengthy. That's why prepacks, were popularized in the US, because it's a way to reduce the length of insolvency proceedings and therefore the cost of insolvency proceedings. Some authors in the US have mentioned that Chapter 11 should be abolished. Should be abolished because it's so inefficient. Other people like Professor Mark Rowe, Professor Lucian Bebchuk, Professor Douglas Baird, Robert Rasmussen, Alan Schwartz, Oliver Hart, the Nobel Prize in Economics, they all mention, well, maybe Chapter 11 shouldn't be necessarily abolished, but at least it should be revisited because it's very costly, very lengthy. It leads to a lot of litigation cost. In a recent article, Professor Jared Elias from Harvard Law School has shown in the past 10 years the fees charged by lawyers and financial advisors in Chapter 11 proceedings has increased by, can't remember the figures, but I think it has increased very significantly. At least in the past few years, the costs are like 3 or 4 times more than what it used to be 10 years ago. So that's why that's kind of crazy. The direct costs of Chapter 11 are very significant, but the indirect costs of Chapter 11 are also very relevant. They basically destroy a lot of values. That's why maybe Chapter 11 is not the paradise that we all envision in the global south. And some people can say, okay, maybe Chapter 11 is not the paradise, but definitely the UK is, and the UK administration. Really? The fact that we initiate an insolvency process and you are automatically replaced by an accountant that might be an expert on insolvency law and financial matters, but not necessarily in the way a business should be run, is going to improve the governance of that distressed firm. A country that doesn't have big financing provisions is really the paradise. The cross-class clampdown has only been recently adopted in the UK. The UK doesn't have a simplified insolvency regime for micro and small enterprises, which are the most common enterprises around the world, including the UK. So maybe the UK, again, is not the ideal insolvency regime that we should look at. What about Germany? Well, again, Germany has recently amended its laws also to adopt a new pre-insolvency framework, in part because the European Union has required that. But again, insolvency proceedings are also very costly in Germany, Spain. I have an entire book speaking about the inefficiencies of the Spanish insolvency system for those of you interested and those of you who speak Spanish. This book is Spanish. But I wrote an article summarizing my book, basically, and the title of the article was The Great Achievement of the Spanish Insolvency Law. And the great achievement was that it's one of the few laws in the world that is an attractive to both debtors and creditors. because you typically think about insolvency systems as debtor-friendly or creditor-friendly regimes. Well, I showed that the Spanish insolvency system was unattractive to both. So that's why I called that article, the title was The Great Achievement of the Spanish Insolvency Law, because it's not easy to end up with an insolvency process that is bad for everyone. I have to say that after the recent reforms in Spain, now Spain has, in 2022, Spain adopted a very sophisticated restructuring framework. And now I would say that Spain, along with the Netherlands, has probably one of the most attractive restructuring frameworks. But before that change, Spain had an unattractive insolvency process. And that's why it's not surprising that Spain was one of the advanced economies with the lowest levels of business bankruptcies. France has a very attractive insolvency regime for debtors, but is incredibly unattractive to creditors, particularly secured creditors. So that's why it's not surprising that the empirical literature has shown that if you want to borrow in France, you need to provide more collateral to your banks, which is something that reduces the availability of credit and increases the cost of credit for individuals and firms, precisely because lenders respond ex ante to such an attractive insolvency regime by requiring more collateral. So that's why the French insolvency regime is not the ideal regime that we should look at either. And Australia and New Zealand that have similar insolvency proceedings, again, it's like based on the UK kind of administration regime as well. Australia and New Zealand have an administration regime, and also they have a scheme of arrangement with the very basic provisions existing in the UK as well. That's why Australia now is currently discussing whether the law should be amended and how. And there was a report that was published a couple of years ago saying that Australia insolvency regime should be entirely revisited. So that's why, again, it seems that the global north is not the paradise that we often envision in the global south. So that's why I wanted to include this meme in the slides, because it's a way to show that sometimes when we think about insolvency law in the global south, we think about this beautiful horse that I show here in the slides, and we all admire such a beautiful horse and we all want to have it. But the reality is a bit different. So that's why I think that this slide summarizes very well the perception and the reality of many insolvency systems in the global south. So to my point about what we can learn about the global south. So many of the problems existing in the global north actually exist in the global south. So when I can see many friends and colleagues here, from Colombia, from India, from different countries around the world. So if I ask them right now, and hopefully they will share their thoughts in the Q&A, but if I ask them about some of the problems and weaknesses of their insolvency systems, many of them will probably say, oh, insolvency proceedings in my country are very costly and very lengthy. Insolvency proceedings in my country are stigmatized, the stigma of insolvency. Insolvency proceedings in my country are unattractive to debtors, or they are unattractive to creditors, or they are unattractive to both. But actually, those problems also exist in the global north. So, for example, the costly and lengthy proceedings exist in the US. They exist, that problem also exists in the UK as well. That's why the pre-packs were popularized in part in the UK and the US as a response to a proceeding that was very costly and very lengthy, and because of the need to reduce the length of insolvency proceedings and the cost of insolvency proceedings. So that's why, in other words, many of these problems that we typically have in mind when we think about the global south, they exist in the global north as well. The only difference, or one of the main differences, is that sometimes many of these problems are exacerbated in the global south. So, for example, in India or in Colombia, if we look at the statistics about the time associated with the initiation of insolvency proceedings in Colombia in 2021, if I'm not wrong, it used to take about 5 months to initiate an insolvency process. So in other words, between the filing and the commencement of the process, it used to take about 5 months. Why? Because the institution in charge of reviewing all the documents submitted by the debtor takes some time to review everything. and because of some institutional weaknesses and some of inefficiencies, it used to take about 5 months. And that's a lot, because if you are dying and you are a company that is dying and you knock at the door saying, hey, I need help, and you go to the hospital cannot say, hey, wait, and sit for 5 more months because they need to review whether you are indeed dying or not, because then, of course, you're going to be treated once you are already dead. In India, also something similar happened. According to the statistics of the Insolvency and Bankruptcy Board of India, many insolvency proceedings used to take about 1, even 2 years if they were initiated by creditors. And if they were initiated by debtors, also a few months to initiate the insolvency process. So that's why some of the problems that I just mentioned, cost and length of insolvency proceedings, stigma, etc., they exist everywhere. Even in the US, the stigma exists in the US as well. So some people believe in the Global South that people file for Chapter 11 because they want to and because they enjoy the experience. They wake up one day and they say, oh, I would love to file for Chapter 11. No, nobody likes to file for bankruptcy. But of course, this insolvency process in the US can be helpful, can be an effective tool to save viable but financially distressed firms. And that's why they use Chapter 11. So that's why the stigma of insolvency exists everywhere. But of course, it is exacerbated in some countries. And as we will see in a minute, sometimes it's exacerbated not because of cultural reasons, but sometimes because of the unattractiveness of the laws and some unattractive aspects of the legal and institutional environment. So my point here, and this is one of the main takeaways of the paper, is that because some of the problems that we face in the Global South also exist in the Global North, we all face similar problems, but some of them are exacerbating the Global South. The Global South actually has thought sometimes a bit more than the Global North about some of these problems. Why? Because they are exacerbated in the Global South. And that's why sometimes they have come up with some innovative solutions. So that's why one of the points that I want to make in this presentation, and I make in the paper that I am presenting, is that why not learning from each other? We all learn from Chapter 11. We all have learned from the European-style insolvency proceedings. We all have learned from the UK-style administration proceeding. But why not learning from Colombia? Why not learning from India? Why not learning from China, from Nigeria, from Chile, from the Dominican Republic? Because they have many problems in their insolvency systems, and sometimes as a way to address those problems, they have come up with innovative solutions. So in my research, I've identified 10 insolvency solutions, 10 innovative solutions that, in my view, can inspire reforms, not only in the Global South, but also in the Global North. And this is one of the most important points of the paper. So we, from the Global South, can learn a lot from the Global North, because mutual learning is always enriching. And actually, we can learn a lot from importing practices from the Global North if they are adjusted and they are tailored to the local context in the Global South. But the reverse is also true. The Global North can also learn from the Global South. And in fact, I identify in this article at least 10 innovations that, in my view, can improve the insolvency systems in the Global North. So the first one is the workouts. So we, as I just mentioned, insolvency proceedings are very costly and also very lengthy everywhere. Also in Europe, also in the UK, also in the US. So if the proceedings are very costly and very expensive, why not trying to promote more workouts? Workouts, to be fair, they are popular, relatively popular in places like the US, in part because the law itself incentivizes workouts. But they are not very popular in many other jurisdictions in the Global North. For example, in Europe. Europe has actively promoted pre-insolvency proceedings, but workouts are not very popular yet. And actually, I mentioned in the paper that we can learn a lot from the experience of many jurisdictions in the Global South. And I mentioned the case of Malaysia, the Philippines, and Thailand. Why is that? Well, because in the 90s, in the late 90s, Asia experienced a financial crisis. So imagine a financial crisis came and many Asian countries didn't have developed insolvency regimes. And they didn't have a very efficient judiciary to handle the wave of insolvency cases. So that's why many Asian countries have to deal with the crisis very quickly. And that's why they came up with the idea that why not promoting workouts as a way to avoid the use of a very inefficient insolvency process, because our insolvency regime is not equipped to deal with this wave of insolvency cases. So that's why Malaysia developed a framework to deal with workouts that has been very successful. The Philippines, a few years later, adopted some provision in its insolvency law to promote workouts. For example, allowing the debtor to enjoy a moratorium if an overwhelming majority of the creditors agree, and also a majority rule. So you don't need 100% of the creditors supporting your plan, but you need an overwhelming majority. That sounds kind of a pre-insolvency process, such as those existing in Europe, but with one important difference, which is that in the Philippine workout, the proceeding, the agreement between debtors and creditors doesn't need to be approved by the courts. So it's like in the UK company voluntary arrangement, if debtors and creditors reach an agreement, that agreement doesn't need to be subject to court approval. This is something that the Philippines has adopted and can also be challenged ex post if, for example, the parties believe that there are some procedural irregularities, but unless the agreement is challenged ex post, you don't need court approval. And then Thailand came with a very interesting solution. If you want to encourage debtors and creditors to reach an agreement out of court, you need to incentivize debtors and creditors to do so. And one way to do it is by using the tax framework, the tax regime. Why? Because if you think about a haircut from the perspective of the debtor, the haircut is a debt forgiveness. It's like a gift to the debtor. And that gift is not taxed if it happens in a formal organization process in many jurisdictions around the world. Not in all jurisdictions, but for example, in the US and the UK. But if the same haircut is granted by the creditors out of court, that tax treatment of haircuts doesn't apply, and that's why the debtor needs to pay taxes for that gift received from the creditors. Similarly, from the perspective of the creditors, the debt forgiveness is a loss, and that loss cannot be deducted from a tax perspective in many jurisdictions unless you show some collection efforts. And if you voluntarily decide to give up part of your claim, you are not showing this collection effort. So that's why this is something that Thailand considered and Thailand implemented. So that's why I think there are many fascinating things that we can learn from the Global South for the promotion of workouts. Also from Uruguay, the US has been debated recently in cases like Johnson & Johnson, whether solvent companies can file for Chapter 11 and whether this is an opportunistic filing for Chapter 11. In the US, the case can be dismissed ex post if you show that it was a filing in bad faith. But of course, that's subject to litigation, and that's subject to litigation cost, and that can create uncertainty, etc. So Uruguay came up with a very interesting, in my view, fascinating solution that can even inspire the debate in the US, which is that if the debtor files for bankruptcy, that is a non-rebuttable presumption of insolvency. So we, in other words, we will believe the debtor. And some people might say, well, but if the debtor lies and if the debtor is filing opportunistically, what happens? Well, in Uruguay, a majority of unsecured creditors can terminate the process. Again, it's not even the court. So it's the creditors themselves can terminate the process if they believe that the debtor shouldn't be reorganized or if they believe that the debtor is filing opportunistically. I think this is a very fascinating solution that can inspire many debates and reform in the global north. When we think about the governance of insolvency proceedings, again, I don't really understand why the UK, Australia, or New Zealand still have this administration regime led by an external administrator. So the management team is automatically replaced. I mean, that makes sense if the managers have done something wrong, if they have committed fraud, or if they haven't been very diligent. Of course, I'm totally supportive of that. But that's not always the case. I actually would say that it's not the case even in the majority of the insolvency proceedings. And in fact, preserving such a rule that the management is automatically replaced can perpetuate the stigma of insolvency, because we are assuming that the managers have done something wrong and that's why they should be replaced. Interestingly, during the pandemic, the UK adopted this light touch approach. And many countries from around the world, they were saying, oh my God, look at the UK. And this innovative approach adopted in the UK, which is a light touch approach, where the administrator is appointed, but doesn't really replace the management team. It works closely with the management team. Well, surprise, surprise. That light touch approach that was, in theory, invented by the UK already existed in Canada with a monitor, and we have Matthew here from Canada that can tell us about that regime a bit more. But also that regime exists in most jurisdictions in the global south, in Latin America, in Chile, in Brazil, in Colombia. The management is not automatically replaced in those jurisdictions. So that's why I think maybe Australia, the UK, New Zealand can learn something about the experience of these jurisdictions with appointment of a monitor and examiner instead of automatically replacing the management team. In fact, my favorite example here is Colombia, because Colombia actually has adopted a debtor in possession, which is like the US regime. But a debtor in possession with a very important innovation, which is that 30% of the creditors, if they want, they can appoint an external insolvency practitioner. So that's why they typically do so when the managers have done something wrong, which is a solution that makes sense to me. If they haven't done something wrong, why should we replace the management? That's going to be creating more cost for the proceeding. Maybe the external administrator doesn't have expertise to lead the process. So that's why the solution adopted in Colombia, in my view, is the most optimal one. And maybe countries like Australia, New Zealand, the UK should look at Colombia maybe to consider this possibility of allowing the creditors to appoint an external administrator, or also in Colombia, the institution in charge of managing insolvency proceedings, the superintendents of companies, can also appoint an external administrator in cases with many creditors, or cases with a particular complexity or international component that may require this type of external administrators as well. Also, we can learn a lot from countries like India. India is one of the few countries in the world where the insolvency process is somehow led by the administrator, by an external administrator, but it's ultimately controlled by the creditors, by a committee of creditors. And then maybe Suman and some of our Indian experts can tell us a bit more about that later. But I think it's one of the few countries in the world that is a creditor in control, but administrator-led insolvency process. That's very different from the UK or the Australian regime, because in Australia or the UK is led by the administrator, but most of the decisions are made by either the administrator or ultimately the courts. In India, most of the key decisions, such as the appointment, removal of insolvency practitioner, approval of new financing, approval, of course, of the organization plan, and many others, they need to be approved by the creditors themselves. They have the skin in the game, and that's why they should be the ones approving this. And also in countries like India, the inefficiencies of the judiciary have led also to the adoption of such a creditor-friendly insolvency process. So that's why allowing the creditors to decide is beneficial, first of all, because it can help us address the inefficiencies sometimes existing in the judicial system, which is a problem existing in some jurisdictions in the global north. In my paper, I mentioned Italy or Greece, for example, where the judicial system is very inefficient. But at the same time, it makes sense for the creditors to make the most relevant decisions, because ultimately it's their money, and that's why their interest is at stake. So that's why I think we can learn a lot from India, and also from many Latin American countries like Chile or like Dominican republics, where creditors sometimes can make, and they are often required to decide some of the most relevant aspects of the insolvency process. Then for cross-border insolvency, so of course, we always think about the model law cross-border insolvency enacted by UNCITRAL. And there are some empirical studies showing that adopting the model law is beneficial. But it's not the only way to promote cross-border insolvency. We have seen successful cross-border cases in India, for example. I think it was with the Netherlands, in the case of an airline, that through a cross-border insolvency protocol, that mechanism facilitated cross-border kind of cooperation and led to a successful insolvency process. And also China has reached an agreement with Hong Kong to facilitate cooperation, a bilateral agreement to facilitate cooperation in cross-border insolvency cases involving assets and creditors and companies in both mainland China and Hong Kong. So that's why I'm not saying that we shouldn't adopt the model law. Actually, I think we should, provided that the model law is adjusted to the local context of the country. What I'm saying here is that there are other mechanisms to facilitate cooperation, such as bilateral agreement, and China has done that with Hong Kong, and also cross-border insolvency protocols, and this is something that India and other countries in the Global South have done as well. When it comes to micro and small enterprises, so they represent the majority of businesses everywhere, not only in your country or mine, but literally everywhere. And countries that have led the debate on micro and small enterprises in insolvency, interestingly, in many cases are countries from the Global South. We can see countries like Chile, Colombia, Myanmar that have adopted very innovative, simplified regime for micro and small enterprises. Some of them are first movers in this space, while, for example, in Europe, particularly in continental Europe, Spain is the only country probably in the entire region, or one of the few countries in continental Europe that has adopted a simplified insolvency regime. So that's why maybe many European countries, or maybe the UK that doesn't have a simplified insolvency regime for micro and small enterprises either, should look at not only the global north, subchapter 5, for example, in the US, or countries like Singapore or Australia that have also adopted simplified insolvency regimes, but also some of the experiences and interesting practices from Myanmar, Colombia, Chile, and beyond. The stigma of insolvency, one of my favorite topics, because we have learned from many kind of scholars, or we are typically used to read, that the stigma is a cultural problem. The culture creates the stigma. Well, I don't think so, because Chile was a country that prior to 2014 didn't have many insolvency proceedings. Insolvency proceedings were stigmatized. Interestingly, Chile adopted a very ambitious insolvency reform in 2014, and now the number of insolvency proceedings is one of the highest in Latin America. So Chile now has thousands of insolvency proceedings per year. And interestingly, prior to the 2014 reform, companies were required to file for bankruptcy if they were insolvent. There was a duty to file. That duty to file has been abolished, and still debtors now use insolvency proceedings more often. Why? Because among other things, the insolvency process now is more attractive to debtors and creditors. Do we want to reduce the stigma? The first step is to improve the attractiveness of the insolvency process for debtors and creditors. Secondly, Chile has adopted many terms that get rid of these pejorative connotations of being bankrupt and all the stigma associated with some of these terms. So, for example, Chile removed the term bankrupt and adopted the term debtor. And so, for example, the entity in charge of managing and overseeing insolvency proceedings is no longer called Superintendence of Bankruptcy. It's called Superintendence of Insolvency and Re-Entrepreneurship. And that's fascinating, re-entrepreneurship, because that's a way to emphasize that you are not longer you are not a bankrupt, you're no longer a bankrupt, but a re-entrepreneur, a person that is, moving from one economic activity to another, and that's why you may need a discharge, or you may need the use of the insolvency tools in order to emerge from that situation successfully. So that's why Chile is literally the best example that I was able to find to show that the stigma of insolvency can be tackled with the right legal and institutional reforms. And also the Superintendence of Insolvency and Re-Entrepreneurship is very active promoting education and research and discussions on insolvency. So that's why in only 10 years, I think Chile is a country that has been able to effectively tackle the stigma of insolvency. Sometimes in Asia, in countries like Australia or like Singapore, many of the Asian countries, we still have the stigma. But sometimes it's because the law is either creating or at least exacerbating the stigma. Why? Because in countries like Australia or Singapore, if you become bankrupt and you want to leave the country, you want to travel overseas, you need approval from the entity in charge of overseeing your insolvency process. Why? Because again, that is still this perception that you did something wrong, or maybe you use creditors' money kind of opportunistically, and that's why you need to be closely monitored. So these restrictions don't exist in many jurisdictions in the global north. So that's why when it comes to stigma, we need to think not only about making the insolvency process more appealing, but also about trying to get rid of all the laws, not only in the insolvency laws, but also sometimes in some financial laws and others that restrict debtors from having access to credit, some corporate laws that might restrict bankrupt debtors from being corporate directors, for example, or serving corporate boards. So that's why I think that there are many things that we can learn from countries like Chile. And just to conclude, availability of insolvency data. So countries like, for example, the US or France or the UK or Australia, they publish very good statistics on insolvency. So that's fine. But there's still many countries in Europe and some advanced economies in Asia don't publish insolvency statistics. Chile and India are countries that publish insolvency, very comprehensive insolvency statistics, and sometimes very detailed insolvency data. So that's why I think that many countries in the global north can also learn from these statistics and this data collected and published by countries in the global south, such as Chile and India. So then why do we find these innovative aspects in many insolvency laws in the global south? Well, apparently, Plato, I didn't know that, but when I did this research, I found that Plato, the Greek philosopher in the Republic, he mentioned something like, innovation or necessity is the mother of all innovations. So with other words, but what he basically meant is that necessity fosters creativity. And this is something that, with other words, has been mentioned also by Albert Einstein. Albert Einstein basically said that when you have a crisis, some opportunities can also emerge from that crisis. And this is, by the way, something that we learned from the pandemic as well, and from many financial crises in the past. Some of these crises encourage people to think about how should we deal with these problems, because we need to deal with them urgently. And sometimes the system, the legal system, the judiciary is not equipped to deal with that. And this is something that Asia thought during the Asian financial crisis. That's why they came up very early and very quickly and effectively with these frameworks for workouts as a way to avoid the use of inefficient insolvency proceedings. And also Europe, after the Euro crisis, after the 2008 financial crisis, Europe started to adopt many insolvency proceedings as a way to avoid also the use of the inefficient insolvency process. So that leads me to Professor Mariana Pargendler's work. Professor Mariana Pargendler said, the Global South has innovated in many aspects in corporate law and corporate governance. And particularly in her work on corporate governance, she emphasized that countries like India, Brazil, China, they have innovated in aspects such as the stakeholder-oriented provisions adopted in their corporate laws. Interestingly, now the Global North is thinking about adopting stakeholder-oriented provisions. Why is that? Well, Professor Pargendler said, in an ideal world, maybe having a shareholder-oriented corporate law makes sense. But she said, you know what? There are many problems in the Global South. Problems of, for example, insufficient state capacity. Sometimes the state cannot provide all the responses that would be desirable or needed. And also problems of inequality and many other social and institutional problems. So that's why she mentioned that the Global South had to be creative. The Global South was forced to be creative to come up with these stakeholder-oriented provisions, maybe as a way to address some social and institutional problems. Interestingly, she said, some of these problems, such as inequality and insufficient state capacity, are now observed in the Global North. So that's why it's not surprising that maybe the Global North now is considering adopting these solutions traditionally existed from the Global South. So again, my message from this paper and from this talk is not that the Global South has a fantastic insolvency regime. Actually, I have an entire book saying that insolvency in the Global South should be reinvented because it has many weaknesses, in part because of the influence of the Global North and the influence of certain practices that don't work in countries with weak institutional environments and with a totally different economic, cultural, and market environment. So that's not the point of the paper. The point of the paper is that mutual learning is always enriching. And we know that because in the Global South, we have studied the Global North. We have studied the US Chapter 11, the UK, Europe, and that's fantastic. The point of the paper is that the reverse is also true. We can also learn from the Global South. The Global North can learn from the Global South, and of course, many other jurisdictions from the Global South can learn from many other emerging markets and developing economies. Unfortunately, when we think about insolvency reforms and debates, typically the flow of ideas and sources of inspiration move from the global north to the global south. We can see Chapter 11 everywhere. We can see the US style, the European style pre-insolvency proceedings everywhere, the UK style administration proceedings everywhere. So that's why maybe it's time to reconsider that. And that's why my advice for some of our colleagues here joining us today, particularly the junior academics doing, for example, a doctoral thesis on insolvency law, I would encourage them to explore a bit more some jurisdictions in the global south, and even jurisdictions in the global south beyond India and China. Of course, India and China are some of the world's largest economies, and it's very important to analyze these countries also because we can learn many things from their insolvency systems. But also I would encourage them to do more research about insolvency law, maybe in the Philippines, in Thailand, in Uruguay, because I think there are many things to learn from this country. So that's why the main takeaway from this paper and the main message is that mutual learning is always enriching, and that's why we need to integrate more actively the global south in the study of insolvency law and the study of comparative insolvency law. Otherwise, we are going to be missing the opportunity to learn from many exciting ideas and innovative solutions that can contribute to the improvement and understanding of insolvency systems around the world. That's all from my side. My apologies for the delay. I think it took a bit longer than expected. The paper is available here on SSRN for those of you interested in analyzing and getting all the details that I mentioned. And now I'm happy to take any questions from the audience. Thank you so much.
Well, thank you so much, Aurelio. This is very insightful, as always. And your perspectives of various aspects which we tend to sort of see through often, they being so obvious. I think that's the biggest strength, because sometimes we consider ordinary to be ordinary enough to be ignored, not realizing that often the ordinary can surprise you. And that's what I think the Global South story is all about. I know that you have a question. I see hand raised, so we'll give another 5, 7, 10 minutes, maybe, for Q&A. So please, over to you.
Good morning. Thank you very much for the invitation. Professor Gurrea, you have talked about the case of Chile, and I thought I listened that the number of cases of insolvency, the company insolvencies increasingly. Is there a relationship between the kind of legal frame for insolvency and the number of enterprise that go to insolvency? The question is the next. If you have more laws that led the sabotage of enterprises, they are going to go massively to the proceedings, and that is a good news for the company law. I don't know. The problem is the more law that made it easy to go to the insolvency is a good news for the legal frame for enterprises.
Okay, thank you so much, Professor Franco. Great to see you, my friend. So thank you for the question. So that's a fantastic question, because your question is really about having more insolvency proceedings is good for the economy, is good in general for the country. And the short answer is not necessarily. So my point about Chile is that the number of insolvency proceedings has increased significantly, exponentially, in the past years. And why is that? Because people are no longer afraid about becoming insolvent and about initiating an insolvency process. So that's why Chile is mentioned, among other things, as an example of a country that has tackled the stigma of insolvency proceedings very effectively. And tackling the stigma of insolvency is a good thing. But having many insolvency proceedings is not necessarily a good thing. Actually, in one of the reforms that Chile has implemented in the past 10 years, for individuals, it was very easy and very attractive for them to file for bankruptcy, sometimes opportunistically, because they were getting a discharge of debt very easily, and the discharge of debt should be allowed only for honest but unfortunate individual entrepreneurs. So in other words, if you are an entrepreneur in bad faith, borrowing money and trying to, get a discharge just to, avoid paying your debts, bankruptcy law should not provide you with that discharge of debt. So that's why I think Chile, in the past reform in 2024, has managed to balance relatively well this attractive insolvency process for debtors, but at the same time preventing or at least reducing the risk of opportunistic filings for the debtor. But this is something that Uruguay has done incredibly well as well. As I mentioned, in Uruguay, if the creditors believe that the debtor is filing for bankruptcy opportunistically, a majority of the creditors can terminate the process. That doesn't happen in countries like the US, for example, or that doesn't happen in many other jurisdictions around the world. In the US, if you believe that the debtor has filed opportunistically, you need to go to the judge and you need to say, Your Honor, I think there is bad faith here, so terminate the process. And then that is going to create litigation costs, uncertainty. So that's why the solution adopted in Uruguay, I think it's very interesting. But to your point, not necessarily more insolvency proceedings is a good thing. So we need to understand why and the type of debtors that are using it. But I wanted to emphasize the fact that debtors are no longer afraid of using the insolvency systems in Chile, in part because Chile has managed to tackle the stigma effectively. Thank you for the great question.
Thank you. Matthew, you wanted to say something.
Yes, no, I do. Yeah. So first off, I actually put something in the chat because
Yes.
Aurelio asked about the monitors. So in case anybody wants to read about it, there's a really great brief summary that is excellent that I refer people to if they have questions about it. Anyway, you can have a look at that. My question is not related to that at all. As many of you know, when you do write a doctoral thesis, you tend to, go through methodologies and stuff. So I kind of got to read quite a bit on comparative law, like the theories that underpin sort of comparative law and different approaches. And one of the things that I couldn't help but suggest maybe or think of when I'm reading through this, especially when it comes to perspectives of the global south, there was an academic in Canada, actually. I think he passed away about 10 years ago by the name of Patrick Glenn. He wrote this book entitled Legal Traditions of the World. And I really think that, and especially some of the later work that other people have done on this, of, using this as a methodology in comparative law, where it basically says that, a law's, that it's almost railing sort of against the functionalist approach to comparative law, where it's basically that the law's function is its most important aspect. And what you're seeming to do, Aurelio, is in this project, you're seeming to apply those methodologies, maybe even unknowingly, which I find, which is, that's not exactly uncommon sometimes, but I would actually suggest that you read Patrick Glenn's Legal Traditions of the World, and I think you could actually benefit quite significantly from it, and especially around gaining perspective on sort of how different legal systems work and how they developed. I think that could actually really benefit this project. So just a suggestion. I thought I would throw it out there while I was on the call. So
thank you, Matthew. Michelle, any other questions? Wade tells me that a lot of people logged on to YouTube listening to us. The young prefer it that way so that they can be anywhere and just be on the YouTube listening to Aurelio as a monologue. But that's great. Any other questions or comments? Well, if there are none, then Aurelio, would you like to make any comment, or can I close?
Yeah, feel free to close. If we don't have any further comments or questions, yeah. Okay.
Well, thank you so much, Aurelio, to you to have agreed to do this. I know it's quite late for you in Singapore, and we appreciate it very much. And thank you also once again for leading the task force. It's very important for us that we are able to create a very resounding message of what we are doing. And of course, thank you all who were there to listen, to participate, to share their views. All of that is very encouraging to us, and we will continue to sort of have this series of dialogues, conversations around this going forward in one or the other avatar. We have a lot in the offing, and hopefully you will see more and more of the task force this year talking about different aspects of insolvency systems in Global South, and of course, looking at Global North at the same point in time. So thank you so much once again. Have a great evening, afternoon, day, depending on which part of the world are you in. Bye.
Thank you, everyone.
Thank you so much. Thank you. Mario, you wanted to say something because you're on the mute. I don't know. No? Okay, very well.